In the modern world, privacy is no longer stolen in the dead of night. It is collected quietly, legally, and often with our unwitting cooperation. Every email sent, every app installed, every website visited leaves behind fragments of personal data. Fragments that can be gathered, analyzed, sold, and retained without most Canadians ever realizing how or why. Canada is often seen internationally as a country with strong privacy values, progressive human rights protections, and a legal culture rooted in fairness and restraint. Yet behind this reputation lies a legal reality far more complicated. Beneath Canada's privacy laws exists a series of gaps, technical, interpretive, and structural, that allow personal data to be collected and used in ways most citizens would never knowingly approve. This documentary investigates one of the least understood but most powerful legal loopholes in Canadian law: the concept of implied consent in digital privacy legislation, and how it enables widespread data collection without explicit permission, meaningful understanding, or real choice. This is not a story about hackers, data breaches, or criminal surveillance. This is a story about lawful data practices, practices that operate entirely within the boundaries of Canadian law while quietly undermining the spirit of privacy. Canada's modern privacy framework emerged in response to the rapid digitization of commerce and communication in the late 20th century. At the federal level, the cornerstone of private sector privacy protection is the Personal Information Protection and Electronic Documents Act, commonly known as PIPEDA. PIPEDA was designed to regulate how private organizations collect, use, and disclose personal information in the course of commercial activities. It applies nationally, except in provinces that have enacted substantially similar legislation, such as British Columbia, Alberta, and Quebec. At its core, PIPEDA is built around 10 fair information principles, including accountability, limiting collection, safeguarding information, and, crucially, consent. Consent is presented as the moral and legal foundation of data protection. The law assumes that individuals control their personal information by agreeing to its collection and use. But the law does not require all consent to be explicit. From its inception, PIPEDA allowed for implied consent, a concept borrowed from contract law and adapted for information governance. In theory, implied consent exists where a reasonable person would understand that providing information implies agreement to its use for a specific purpose. In practice, this concept would become one of the most expansive and consequential loopholes in Canadian privacy law. The privacy loophole begins with a simple legal assumption that users understand what they are agreeing to. Under PIPEDA, organizations must obtain consent that is meaningful. However, the statute does not strictly define what meaningful means in a digital context. Instead, it relies on a standard of reasonableness, what a reasonable person would expect under the circumstances. This creates an interpretive gap. In many digital interactions, consent is implied rather than expressly given. When a user installs an app, visits a website, or signs up for an online service, consent is often inferred from behavior rather than clearly stated agreement. Clicking "Accept," continuing to browse, or merely using a service can be treated as legal consent to extensive data practices. The loophole exists because the law evaluates consent based on form rather than comprehension. There is no requirement that users read, understand, or realistically grasp the implications of privacy policies that often exceed tens of thousands of words and are written in dense legal language. As long as an organization discloses its practices somewhere, Even deep within layered policies, implied consent can legally exist. This allows data collection to expand far beyond what most Canadians would reasonably imagine they have authorized. Consider a hypothetical Canadian consumer who downloads a free weather application. The app requests access to location data. The user assumes this is necessary to provide local forecasts. What the user may not realize is that the app's privacy policy, buried behind multiple links, allows precise location data to be retained indefinitely, shared with third-party analytics firms, combined with advertising identifiers, and used to build long-term behavioral profiles. Under current Canadian law, this practice may be entirely legal if the organization claims that a reasonable person would expect a weather app to collect location data. The gap emerges in the scope of that collection. The law does not require the organization to distinguish between functional use, showing the weather, and secondary uses, data resale, profiling, cross-platform tracking. Consent for one is often treated as consent for all. In another scenario, a Canadian employee uses a company-issued smartphone. Metadata about calls, app usage, and location is collected for security and operational purposes. Over time, this metadata reveals intimate patterns: religious attendance, medical visits, political meetings. Because metadata is often classified as less sensitive than content, it may be collected under implied consent without explicit disclosure. The individual never actively agrees, yet legally, consent exists.